Welcome to Work Comp Talk, a podcast dedicated to all the injured workers here in California. I want to thank our lovely sponsors, Pacific Workers, the lawyers for injured workers. If you have not yet been able to connect with an attorney who can feel like they're listening to you, who is going to be there every step of the way, I highly encourage you to check them out at pacificworkers.com, especially if you're starting to get into some issues within your workers' compensation claim. My name is Carmen, your host, and this is the Best of Work Comp Talk series where we highlight the best episodes from the podcast into one. It's very important for you to hit the description. That way you get actual links to the full episodes of those topics we will be highlighting in this episode. And I also wanted to give you a heads up. Season 5 is coming up. It's coming up pretty soon, and I'm excited because I'm going to be able to share so much more knowledge with you as I embark this new season, along with many other co-hosts that are also attorneys for workers' compensation. So we're going to get different views and different concepts, different ideas that are going to come from these other attorneys. And you'll also get to meet other great people that belong to Pacific Workers. So I hope you join us for this. And I also hope you like this best of Work Comp Talk. I'll catch you guys next time. Welcome back to another episode. And today's episode is exciting because we're going to be talking about money, which I think is one of the hottest topics in anyone's life. Who doesn't want to know about money? In this scenario, we're going to be specifically talking about money that gets added to a case. How do they come up with amounts? How do they come up with settlements and everything regarding money? So where do you want to begin?
I think it's important to understand how workers' comp cases are valued generally.
That's a great.
Essentially, no-fault benefits delivery system. And so the idea was to reduce the amount of damages that employers could potentially have to pay out, but also make it a system where it's more convenient to the employee to recover medical care and benefits for lost wages and such because of injuries that happened on the job. So because of that, the damages were really set by statute. You got things like permanent disability, temporary disability, you got free medical care. And these would all serve in lieu of damages that you would see in negligence case, like in civil court, which are things like pain and suffering, future lost earnings and things like that.
Made me cry. I'm going to sue you and I want money for my T-shed.
Yeah, that among other things, or the fact that, I'm in pain all the time and I can't do the things I love anymore and things like that. And so unfortunately, though, like all things that insurance is involved in, it becomes more so about cutting costs than delivering benefits. You have for-profit business, which is the insurance companies, involved in what's supposed to be a no-fault benefit delivery system. And delivery system is important because it's there supposed to be for the benefit of the injured worker. It's not supposed to be something that is litigious where people are fighting about saving costs and cutting costs over time.
How does then the monetization for an injury come into play? We know that permanent disability has certain ratings. Can you explain those ratings and how this comes into play?
And it's important to understand the distinction that a whole person impairment rating is a rating percentage that a doctor gives you based on either a diagnosis or a particular limited amount of function that you have for a particular body part. That number, that percentage, then gets adjusted by various factors. There's one that's called a diminished future earning capacity adjuster. There's an occupational variant, and then your age obviously impacts that what permanent disability rating is. And so you take a rating that a doctor gives, a whole person impairment rating, and that can be adjusted up or down based on those things. So for-profit business, insurance companies want to save money. So obviously you can assume that any offer that the insurance company is giving you is motivated by the fact that that is less than what their cost actually is going to be long-term. So you can just assume that anytime they offer you a settlement, there's some calculation involved that's designed to reduce costs, and that's probably the primary basis for what they're offering. They want to take more in premiums for their shareholders. So that's a primary motivation for a lot of insurance companies, is to close them fast at a low cost. But they have experts, they have, actuarial scientists and stuff on staff, and they look at risk, is what they call it, to say, well, hey, if we keep this over this long, or this type of claim it is, what is that going to be our cost long term? And so they'll look at what they've spent on the claim so far. They'll look at what the permanent disability might be given the medical conditions. They'll look at your medical treatment history for the claim itself to say, hey, this person's cost us, $500,000 already. It's only been 1 year. What's a lifetime of this going to cost us? Money. And so they're going to say, oh, well, I'm going to jump at this because it's great. Maybe it's not going to be. They're going to say, oh, well, I'm going to jump at this because it's great. Maybe it's not going to be.
And there's the case where the person hasn't been receiving money. They can't make ends meet. They're not working. So having a check, $25,000, is going to kind of ease those pains for the moment, but you're not thinking long term. And some people probably do go for that bait.
The adjusters are motivated to get things done. And they do have a certain level, they call it desk authority or field authority for a lot of adjusters, where at a base level they have some limit of settlement authority, and it goes up to a certain amount. So that number could be like $25,000 or $50,000. And so you'll see adjusters usually throwing out numbers like that range because they don't have to ask anyone for that. That's just money they have as authority within their position. When you start getting into the bigger amounts, then that typically gets more higher up attention, and those amounts need to be approved. They need to work up the value and ask for permission, things like that, and go and justify why they're going to offer that amount. So
I'm super glad that we're talking about this, because how else would an injured worker even know this information if it's not being provided out there? And like you said, yes, there may be a green fat book somewhere out there, and it's not Green Eggs and Hams by Dr. Seuss. But attorneys do free consultations. If they are trying to charge you, then that's not
they'll give you a pretty decent assessment. Most of the time, to be 100%, we can't tell you what your case is worth. We can't tell you all information that you probably want to know up front. That's just not how workers' comp works.
Yeah.
But sometimes people have out-of-pocket medical expenses. So if a case was denied and you had to pay through your own insurance to get medical care, you might have some medical bills. Or in the case of the insurance company not doing what they're supposed to do, you might have had to go to your doctor even on an admitted case to get something done.
Yeah.
So you might need reimbursement.
Prescriptions
or even, medical procedures and stuff. We also see medical mileage where people are entitled to mileage reimbursement for their traveling to and from medical appointments, pharmacies, physical therapy, stuff like that. That usually gets thrown in as well. And then, of course, there's penalties and sanctions. Oftentimes we get, huge amounts of money added onto cases just because we caught the insurance company doing something they weren't supposed to do.
There's a lot we're going to unveil today. And in particular, penalties, sanctions that people don't even know they have a right to when it comes to dealing with their workers' comp case. Where do we start?
Well, I think it's important to understand, what penalties and sanctions are and, what is the procedure for actually getting them. They are available to people.
Let's do it.
So penalties and sanctions are a way that an insurance company, potentially even an applicant, depending on the situation.
Wow.
And the idea is that the court wants to make sure that the insurance company and everyone else is really holding up their end of the bargain and doing what they need to do.
Which, unfortunately, we've learned with so many cases, that's not usually the case.
More so. One of the most common ones, I would say, is when an injured worker is not receiving their payments on time. Or
what type of payment? Or would this be the disability benefits?
Could be both.
Wow.
So throughout the life of a case, injured workers are entitled to things like temporary disability as well as permanent disability. And I think oftentimes checks go missing or the insurance company doesn't pay because they disagree with a medical report. When the insurance company hasn't paid benefits, they're on the hook for late penalties, which can be up to 25%, 10% if it's self-imposed. And potentially also sanctions for, bad faith, frivolous conduct. You have something in your war chest to use. You're not just at the mercy of the insurance company, and there is a way to hold them accountable. I guess the one issue is that, are the penalties and sanctions really proportionate to the damage they're doing? Let's say you have a $1,000 check you're owed, which is, a lot of money. But let's say that $1,000 check is late. They owe you $250 in penalties. $250 in penalties really move the needle in punishing a multi-billion-dollar insurance company. I don't know how effective it is. In civil court, you have things like punitive damages, which are entirely designed to punish. You often see cases where someone's punitive damages are like, 9 times, what the actual damages are, and it's because it's a big company and they deserve a bigger slap than they would otherwise.
Right.
But in workers' comp, it's labor. And then when you're looking at settlement documents themselves, so, it's typically written in there that, there's no penalties or sanctions if payments made within 30 days from the date of the award. So the insurance company does have time limitations built in, and I would say more often than not, it's usually late checks and late settlement payment that we see the most.
Yikes.
I would say late temporary disability checks or late permanent disability checks are probably the most common. Mm-hmm. Every once in a while, there's a late settlement payment, and in payment, you're talking about a more significant amount of money. If someone's owed.
If someone is not represented by an attorney in any way, shape, or form, is this something that they can potentially appeal? Is this something they can move forward with on their own? Easy?
You could try. You have to try the issue potentially. Depending on the insurance adjuster, if you understand the law and what your benefits are and what rights you have, you could make an argument to them and maybe they'll believe you and, say, hey, you know what, we'll pay you. And oftentimes we do negotiate penalties without having to go to court. But usually it's some discount on what the penalty is to just actually pay it. Like let's say there's a disagreement about temporary disability. We think they should have paid, there's a penalty. Maybe it's not that big. Maybe it's like $100 or couple $100 or something like that, and the insurance adjuster says, oh, you know what, I'll pay the whole amount plus I'll pay a 10% penalty instead of a 25% penalty. They're willing to do it right then and there and get the check out to our client. We try to balance everything we do, when we try to make sure that if we're going to take a particular course of action, it's worth the time and effort to do it, and also it's meaningful for the client. And we also try to get things resolved. I think we try to give the insurance company an opportunity to remedy things. We're required to. So when you actually file for a court hearing, you're supposed to certify under penalty of perjury that you've informally tried to resolve the issue before, requesting the court's attention. You can't just file for hearings whenever you want, left and right. And then even once you get a date, assuming that you can't work it out informally and you've wasted that time, you still have to wait for the court to hear your case, which, it could be a month. It could be 60 days, depending on what the issue is. And all the while, the injured worker, the client's still sitting there, and they're not getting their benefits or they're not getting their treatment. So clients have always explained it's frustrating for their perspective. And, I get it. It's just we're also operating within a very limited system with limited scope of rules and limited tools that we can use to move things forward.
And this takes it back to my opening statement. Do insurance companies really have your back when it comes to the California workers' compensation system? For the most part, they should. They want to. But there are situations that they get themselves into that prove otherwise.
I think you always want to make a strong case for it. If you are going to get penalties and sanctions, make sure you have everything lined up. Make sure documenting your efforts. For example, if you feel like your benefits were unreasonably delayed, make sure you have letters and emails supporting your communication with the adjuster or the defense attorney, expressing that your payment's late and why. That way it's ammunition when you go to court. If you need trial exhibits, for example, you can show the judge to justify it. Make sure you get a copy of the request for authorization that was faxed to the adjuster. So you have fax confirmation that was provided to them. So if they don't issue a timely utilization review decision, you can say, look, here's proof that it was sent to you, and now you need to authorize my treatment. So those are good tips, but yeah.
It's crazy. Well, it's good to know. Yeah. Well, that wraps up this episode. We hope you really got a lot of information useful that you can essentially learn if you're fighting a workers' compensation case here in California. Like always, if you have any questions, make sure you dump them in the comments section, or you can always reach out to us on social media. Make sure you guys hit that subscribe button so you guys get notified when we upload new content, and we'll catch you guys on the next episode. Thank you.
We do have our wonderful guests here today, Dr. Jamozby, Donnie Cho, and Dr. Morley, who are going to be explaining everything there is to know about primary treating physicians, nurse case managers, and physician's assistants in the workers' compensation system. Dr. Jamozby, tell us a little bit about yourself, your background, your education, and what you do.
I actually have an engineering background, undergrad, and went to medical school after that. So I had a good perspective of work environment before entering medical school. After medical school, I did a year of general surgery internship, did my anesthesia residency at University of California, Irvine, and then came up to Stanford and did a interventional spine and pain management fellowship. And our practice developed in that direction, and now we have a very large workers' comp practice in Northern California.
Yeah, my background actually started in the tech field. I was working for Johnson for a bit, and then decided to do a career change and went to PA school.
Dr. Morley, how about you?
I'm a lifelong Californian. I always wanted to be a doctor. And then when I was in college, I became involved in doing hospice work. A family member of mine ended up passing away from cancer. And then I knew I wanted to go into pain medicine when I finished medical school residency. And then similar to what Dr. Jamozby said, our practice really focused on cancer pain management. We started being sent to a lot of injured workers who had a variety of problems causing chronic pain, and became very focused. Probably 70-80% of our practice now is treating injured workers.
And for any of you, tell us a little bit about what Pain and Rehab Consultants is. What's the philosophy for business and your medical practice?
We concentrate on really rehabilitating patients from their chronic illness or their chronic pain.
Even though that's not our primary specialty, we really do provide comprehensive care. We're going to take on the responsibility for that entire injury and making sure that patients are sent to us, get the entire workup and treatment they need, no matter what specialty it's in.
In your particular context, what is a primary treating physician?
But in between that, you really do need a captain of the ship. And I think that some physicians are willing to take this on more than others, Bilal, as you've seen. But you have to make sure that essentially that injured worker is getting all the workup and treatment that they deserve and need in the workers' compensation system.
I think Dr. Morley put it really well. The primary treating physician is responsible for getting all the treatment authorized. So it's really important to have a primary treating physician that understands not only the medical illness, but also the system. How does the system work? How do I get the treatment authorized? And the primary treating physician needs to understand those timelines and those requirements so that the patient's case moves along, as well as being able to get the appropriate treatment.
Can you explain what that is?
Yeah, I'm just going to give you a little historic perspective. When I started practicing, there was an assumption of correctness for treating physician, which means that the treating physician recommended something. There was a 99% chance that the patient will get that approved within a day or two. That went away, and the insurance companies provided extra barriers to limit treatment so that there's cost savings. And those limits have become more stringent over time. First, we had utilization review, which could be challenged. Then they made it more stringent. Then they developed IMR, which is independent medical review. But it's basically allowing the insurance company to monitor and possibly deny some of the treatment. The utilization review system is not a perfect system. The doctor that reviews the treatment request is usually not someone that is familiar with the patient. They've never examined the patient or interviewed the patient. They have access to a limited amount of medical information. So the decisions are not the best sometimes, but that's a system we have to work with. So as primary treating physicians, we have to become experts of how to interact with utilization review to maximize the possibility of getting treatment authorized.
Would you say that utilization review has impacted your practice in patient care for the better or for worse?
I think that it has made getting treatment authorized a lot more difficult. And we obviously do not agree with the denials, because when we recommend the treatment, we have already considered all the possibilities and we have picked the best treatment for that patient. And when we request something, we are certain that's what the patient needs. And when the utilization review denies that treatment, it makes things more difficult for us and for the patient.
So piggybacking on that, Dr. Morley, how do you set expectations regarding treatment process with your clients?
Most of the patients we've seen they've had some experience with the workers' compensation system already. Generally, they were sent to an occupational medicine clinic, and they've been in the system for a couple months, and things haven't happened very fast. And most patients that I see come pre-frustrated, I would say, with not really having their expectations met for quality medical treatment. And I think that I have to be realistic with them and say that the treatment I request is not going to be authorized as quickly as their experience has been, like you said, seeing their regular doctor. When their regular doctor wanted a blood test or an X-ray or an MRI, they are probably getting it done that week, and that's not going to happen in workers' compensation.
For example, I had a patient that was authorized for physical therapy, had 6 sessions, was starting to have some benefit, and then they denied more. And so what I tell them is, hey, you got to keep up with your exercises, the things that they taught you, the stretches, so that if more physical therapy is authorized later on, they can take you from here to the next level instead of starting all the way down at baseline.
Do you guys have any idea anecdotally what percentage of requested treatment is denied versus authorized?
We know for our practice precisely. If The process to get treatment authorized is a formal request. That's called a request for authorization. You're supposed to get an answer for that in 5 days. So at an initial yes on a treatment request for us is about 40 to 50%. And it varies a little bit on the treatment, whether it's medications or some other type of treatment. After that process, if they deny it, you can appeal the utilization review decision. That's called utilization review appeal. And then if that's also denied, you can go to something called independent medical review, or IMR, which you've heard us mention. IMR is very similar to utilization review, where you don't meet, they don't talk to you, they just look at the records and decide whether you get the treatment. After that's all done, we get about another half of the 50% denied. So we get to about 70 or 75%. That's pretty rough for patients.
And one of the things I've seen your practice do in particular is actually the appeal at the physician level. There's a lot of practices where they rely on the attorney's office to file things like independent medical review. So can you describe a little bit about what that internal appeals process is on your end? And what is the difference between a nurse practitioner and a physician assistant? In the realm of patient care, what is the role of the physician assistant or a nurse practitioner in conjunction with working with the doctor?
The nurse case manager is really designed for complex patients. Like, there are patients who have multi-organ system injuries, their care is really complicated, they have multiple doctor's appointments, and the purpose of the nurse case manager is to come in and facilitate their medical care, explain to the patient what's going on, maybe help with authorization, and in general, help the doctor get the patient through the system. Unfortunately, that's not what happens all the time. Sometimes insurance companies hire nurse case managers to push the legal case along. But in general, if there is a nurse case manager that is helping with managing the patient's care, they can be very useful.
I would just add one thing. I totally agree with Dr. Jamozby that most of the time, actually, our experience has been positive. Nurse case managers are honestly trying to help the injured worker and get the care they need, but not always.
My experience is that most of the time, the patients don't want them in there. And I don't really see any use of a nurse case manager being in the room with the patient. It just crowds things up. My recommendation is always for nurse case manager to stay outside the room and then come in afterwards when I'm explaining to the patient what's going on. And I think it's important for her to be there because I want that nurse case manager to hear what I'm saying independently and hopefully help me facilitate the treatment.
I would agree with that in most cases, except for cases where we have patients that have brain injuries, right? And they have memory and concentration issues.
Yes, I have. Absolutely. I think the nurse case managers are hired by the insurance company. The theoretical purpose is to facilitate care. But a lot of times what happens is that the nurse case managers get involved in the management of the disability part of the claim, and there's motivation to move the case along to a permanent and stationary status so that the claim can be closed. I do want to emphasize that for patients, they have the sole right of refusing a nurse case manager to come in the room with them. I don't think they should feel forced that somebody be with them.
So we talked a little bit about some of the roadblocks. Sometimes it can be nurse case managers. Sometimes it can be utilization review. Are there any other particular roadblocks you feel like you frequently run into when trying to give patients the care they need?
One of the biggest problems I see is access to specialty care. If you look at the medical provider network in workers' comp, there is orthopedics, there is physiatrists, there's pain management doctors. But then if patient needs another specialty, it's very difficult to find a psychiatrist, almost impossible. So getting specialty care outside of the musculoskeletal system, I would say, is nearly impossible to coordinate. Even if you can get it authorized, the patients usually end up not seeing the doctor because the doctor doesn't really see workers' comp patients. So that's a huge problem in workers' comp. And we've had people with eye injuries, people with liver injuries, internal medicine problems, dermatology. People have disfiguring problems and they need dentists, they need plastic surgeons. Those are very difficult to access. And the other issue is that the patients encounter is when they have multi-system trauma. They come out of a trauma center, they're 2 months out from San Francisco General Hospital or another trauma center, and they come out in wheelchairs with braces. They need to see occupational therapists, speech therapists. So there's this complex system of care that was given to them in the trauma center or in the hospital, and they come out, and every single one of those has to go through utilization review, an IMR, and it becomes literally impossible to provide care for those patients.
A big roadblock sometimes is the employer, right? These injured workers are injured. We have them on work restrictions. We're trying to get them so that they can get the treatment that they need without aggravating their pain at work. And we get sometimes patients that say, hey, my employer's not honoring my work restrictions. I'm aggravating my pain at work.
Try to find the right doctor right at the beginning. A lot of times patients end up at clinics that are basically spinning their wheels. They waste 3-4 months of time. They don't really get proper treatment. I think it's important, if you're injured and you want to get better, make sure you access the proper medical provider right away. Understand how long you're going to get paid for your temporary disability. Understand what the limitations are so that you can get the proper treatment on a timely basis and hopefully get better and move on with your life.
Just remember that your number one asset is your health. You can't be useful to your family, your friends, your community unless you're healthy yourself. And there's going to be a lot of things that probably do happen during workers' compensation claim that are frustrating. Try not to take it personally. Stay positive, get better, because that's really what matters. Hopefully you have a good attorney helping you, have a good doctor helping you, and you're going to make your way through the system. But what really is more important to you at the end of the thing is that you being as healthy as you can be. That's the most important thing.